Thanks for tuning into the Law Offices of Mark Martinez. I'm Mark Martinez, and today we're going to talk about title disputes. What to do if you and a co-title holder are in material disagreement about what to do with a piece of real property. And this is commonly known as partition of real property. It's comprehensive statutory framework under California law in the Code of Civil Procedure 872.010 et sec. This provides the framework for what the court does and how it rules on a partition of real property. Archaically speaking, when the law was originated, there could be a partition of real property in kind or for sale. Partition of real property in kind means an actual division of a lot, that it would be divided in half. Sale means you sell the property and divide the proceeds. And that's typically what happens in today's world, where there's two title holders. One wants to sell the property, the other wants to continue living in it or collecting rent. So there's a material disagreement. A couple other things to note on this type of lawsuit is that this is a lawsuit that cannot be initiated between husband and wife or spouses that are legally married. This is only for those individuals that are outside of marriage. If it's inside of marriage, then typically some type of division of property would have to be done within a divorce proceeding. The other thing to keep in mind is that if there is a lawsuit that has been originated either by yourself or the other title holder, if there is no type of resolution before trial, no type of settlement agreement, no type of agreement for somebody to buy the other individual out, then the court is forced to sell the property. So thank you for tuning in on the partition of real property. This is the general overview, and best of luck. Welcome back to the Law Offices of Mark Martinez. We are going to continue our discussion into disputes between two title holders on a property, otherwise known as partition of real property. There is another video that gives you a general overview of how a partition of real property or how these title disputes between two title holders work. We've already had a video on that, so we're going to go a little bit more in depth on this video. And now that you've been sued or that you find yourself defending yourself against another title holder in a lawsuit, let's take a look at some other considerations here. So the first one is going to be that this is going to be a type of lawsuit that's going to be decided by the judge. There is no right to jury in this case, so you will not have an election to have this decided by a jury. It will be decided by the judge sitting on the bench, so keep that in mind. The second thing is that these cases begin with the assumption that the way that title is held is how the parties wanted to divide ownership. So, for example, if it says Mark Martinez and John Smith as joint tenants, then the law is going to begin and the judge is going to begin assuming that that's how the parties owned the property. And however, the law does allow either party to bring in clear and convincing evidence proving the contrary. How is this done? Well, it's done through evidence, perhaps that you've paid more than your fair share of the mortgage. Perhaps you're paying all of the mortgage. Under a case known as Millian v. De Leon, either co-tenant is allowed to receive a credit for mortgage payments, tax payments, insurance payments. For example, if your mortgage payment is $2,000 and you've been paying all of the $2,000 while your co-tenant has been paying $0, then for each month like that, you would be receiving a $1,000 credit. The other thing to keep in mind is that under the partition of real properties, attorney's fees are allowed to be awarded. Under this Code of Civil Procedure 874.040, the court is allowed to award attorney's fees to either party in furtherance of the real property. So thank you for tuning in. I hope this explains a little bit more of the partition of real property.